Good afternoon, good afternoon, good afternoon again, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and we're going back to that horrible world known as the JRC. But before we do, the usual disclaimers, and we're just going to jump right into it here. In the description box, you're going to find a link to the article that the Judge Rotenberg Educational Center doesn't want you to read. It's written by NeuroClastic, a small non-for-profit started by autistics for autistics, wherein they interviewed and surveyed over 900 ABA professionals in regards to the JRC's so-called behavior modification program. Matter of fact, the JRC doesn't want you to read this article so much, they have threatened NeuroClastic with a defamation lawsuit if they did not remove it from the website. Well, folks, NeuroClastic has refused, so you know the drill. Please read that article and share it on all your social media. Also included in there, NeuroClastic's public statement regards to the defamation lawsuit threat, as well as a link to their GoFundMe. We are crowdfunding in case the JRC actually one day sees through with their threat. Also included in there, the Ozarks first article regards to the Agape boarding school, now known as Stone for Help boarding school situation, a so-called Christian-themed boarding school based out of Stockton, Missouri that takes in so-called troubled male teens that has impending over 21 civil lawsuits, claims, and allegations leveled against it, all which have been substantiated by the Missouri Department of Social Services, and they include the following: sodomy, rape, sexual assault, child abuse, psychological and emotional abuse, child trafficking, starvation, and that's just for starters. You have one former staff member arrested by the FBI, another a doctor still on the premises with full access to the boys up on multiple, again, substantiated claims of sodomy, rape, and sexual assault of the boys there. You have an attorney general too busy chasing after drag queens and trying and failing to defund public libraries to actually do his job. And you've got a governor who's off his nut. So please send help to the few remaining sane people still left in this hellhole. Read that article, share it on all your social media. We have all the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive on the subject, Jennifer Basemba's behavioral sheet of shockable offenses, a clip out of the 7-hour ordeal undergone by Andre McCullens back in 2002, the templates, and the ever-present self-explanatory change.org Shut the Judge Rotenberg Center Down petition. When we discuss the JRC, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with disabilities being tortured and abused. If you got young children present, please use your headphones, all right? This channel is marked not for children for a reason. Trigger warning, we do use profanity on occasion and speak on dark subjects. If your child is 16 and younger and they are watching this, very obviously, parental supervision is very much advised. Trigger warning. This article, written by one of the students for the New England Law Review back in the summer of 1988, is heavily slanted in the favor of aversives and punishment regards to people with disabilities, as opposed to, actually dealing with the triggering issue that's causing the behavior. You're going to hear many things that are very much in the favor of the torture of kids with disabilities. So please be prepared for that. I do want to make note of the fact that eventually we're going to go through the notes version of this article. I want to go through what they're writing first, and then we're going to see what this so-called thought process is. You're going to hear rants. You're going to hear curse words, so just be prepared for that, all right? All right, where we left off. There is no question that those afflicted with self-destructive, life-threatening behavior and extreme levels of violence are in need of treatment, even to survive the institutionalized setting. Again, this is what the JRC totes. They are toting we are out of control, that we are violent against ourselves and others and have to be sent to these places for our own safety and that of the community. It's a lie. It's a big lie. Because when you have surveillance footage of a person being tortured for refusing to remove their coat when they have done nothing to anyone, I would go ahead and argue, even for those who do have these issues, it is not okay to torture them. If you're not allowed to do these kind of things on war criminals, why is it okay to do against us? I'm sorry, but the whole argument of extreme violence doesn't work when you refuse to use it on violent war criminals, okay? Because I guarantee you, their levels of violence against their fellow human beings is far worse than anything that I or any other disabled person gets up to. That's a guarantee. You should think about that. The controversy arises over what is the best treatment in the short run with the prospects of long-term benefits for the patient, family, and the community. The debate is whether or not aversive therapy of treatment or is it punishment and within the powers of the state agency to prohibit. It's punishment, Karen. It's torture. All right? You are... But it's not punishment, it's consequences. It's the same thing, Karen. Instead of dealing with the triggering issue, you are punishing them for the behavior that is stemming from it. That doesn't solve the problem. That just builds resentment, as Paul, the roomie, has so wonderfully laid out in clear, basic, unfailable logic. Do parents have the primary obligation and right to choose the most effective treatment programs for their children? To a point. To a point. But if that so-called treatment causes physical and psychological harm to that child, which can be proven, folks, we have the ER documents. We post that archive for a reason. You will find ER documents about the mental and psychological harm that is done to the kids that are stuck in this hellhole. Okay? If a parent is opting for this so-called treatment for their child, my opinion is that custody should be removed from that parent, forcing their child to go through this immediately. Immediately. If so-called treatment is actually causing harm to children, yes, family court has every right to intervene and should. And I don't mean on the side of the school where the kids are being sent to be tortured. Okay? In general, parents do have the right to make decisions in regards to their kids' physical and mental health. This is true. But when that treatment program causes infinitely more harm than good, when that treatment program is not a treatment program, it's a torture program, no, I'm sorry, they do not have the right to subject their kids to torture. I'm going to call it out as it is. Sleep deprivation, food deprivation. At this time period, pinching those kids until they bleed, leaving barely any piece of unbruised or unscabbed over skin, tying them to poles and forcing them to urinate and shit themselves and sleep like that. If you are a parent who signed your kid up for this and you are fighting to keep them within it, you do not deserve to be a parent, and you should have all custody and authority removed from you immediately as regards to having any kind of decision-making power with that kid. You shouldn't be allowed within 1,000,000 yards of said kid. And no, I'm not sorry. Let's read this bull crap where they're going to defend the parents. Families have traditionally been entrusted with the duty to maintain and provide health care and education for members of the household. This obligation is recognized as belonging to the parents. While some courts have designated this as a parental right, it may be analogized as a trust. The parents is the trustee for the minor of incompetent. Thanks, Karen. For the benefit of the emancipated child, beneficiary. Under this theory, the trustee parent's decisions are made with an eye to the future when the beneficiary will have full control over and responsibility for himself and his actions. Under this quasi-trust theory, the state, seeking enforcement of rights of the beneficiary, intervenes in the family relationship when it has perceived that the trustee parent has failed in the duty to care and protect the child. Waste to the corpus. Exactly. If you're sending your kid to this hellhole, you're failing. I don't even understand how this is a debate. This person is talking about an institution. And yes, JRC, you're an institution. You're an institution with a bad acid trip paint job and even worse decor skills. Okay? If you willingly agree, knowing what they're going to be doing to your child, the state has every right to intervene on the behalf of the child that is being tortured. I don't understand why this is even a debate here. The state steps in to apply the principles of best interest of the child. However, in Massachusetts, this trustee parent obligation cannot be displaced by the state intervention unless there is a showing by clear and convincing evidence that the trustee parent has forsaken the fiduciary duties owed to the child. How in the name of God can that kid come in there bruised, broken, and bleeding? Or in this case, being tied to a 4-point bed face down with a helmet on, dying of asphyxiation. And how in the name of God can you convince me that the parents did not fail here? That the place that they put their trust in did not fail? Are you on crack? Is crack what you smoke? To what extent may a court implement a substituted judgment order? The courts have attempted to set limits of state interference with family decisions on medical care while protecting the rights of the patient through determinations of substituted judgment. What the child, ward, or incompetent would have done if making the decision alone. If any of you all think that any of us would sign up for the JRC and its torture, I got a beachfront property that faces the ocean out in Kansas I can sell you. Rock bottom prices. You got $1? It is an effort by the courts to think as the individual have if the person knew and understood all the circumstances pertaining to his condition. If you think that this is true and you think any of us, with our full competence, as you put it, intact, would choose to be tortured in such a manner, you smoke crack. Okay? Just say. I mean, granted, this was the 80s. They probably... No, we're not going to go there. This doctrine has imposed compulsory medical treatment on competent adults as well as even though it is an invasion of a personal liberties guaranteed by the Constitution. I have the constitutional right to torture my kids. Jesus Christ. The requests for substituted judgment have run the gamut from life-sustaining treatments to discontinuance of life support systems. Each case is treated as one of the first impression when the court considers what type of treatment will or will not be allowed. Because a particular course of treatment was ordered for a person with a specific disease in one instance, is no guarantee that the next person with the same disease will receive a similar order, although there is consistency in factors weighed in reaching a decision. Thus, judicial proceedings requesting substituted judgment orders are based on the consideration unique to the patient, and determinations are not made without substantial deliberation. I call bullshit. I call bullshit. Want to know why I call bullshit? Because when has the Massachusetts courts ever said no to someone going into the JRC? I want someone out there who defends the JRC to provide for me one instance, just one, where the state, the Massachusetts state courts, has ever said no to any student entering the JRC onto aversive procedures. Because I don't think you're going to find one. Not a single time. So that means there is no real deliberation there. Okay? This is simply a judge whose paperwork passed their desk and they signed their name, and that's it. Okay? I would believe there was actual deliberation if we had evidence or proof of a single instance, just one, where a judge said no to aversives. So I'll leave that challenge to anyone who wants to defend the JRC. Provide for me evidence that for one time that the Massachusetts courts has ever said no to any JRC student being put on these devices or on aversives. Just one. I mean, there should be plenty of evidence, right? This decree has been in place now for over 30 years, going on 40 years. That's a lot of different students have come and gone since then. Provide for me one instance in all those years where the court has ever said no to the JRC, known back then as the BRI. One time. One time. There's a flaw in the argument here, both on the parents' side and in the idea that the courts will actually do their jobs and step in. Because very obviously they are already slanted in the favor of the JRC. Even the lawyers on the state side are very obviously siding with the JRC, and they're tired PR bullcrap of how it's because of their extreme self-aggressive behavior and towards that of others. They've had literally multitudes of lawsuits, ER documents, DESI reports, and cases that have all proven what this school actually gets up to behind closed doors. As I've said so many times, our receipts have receipts. And yet in all of that time, in spite of the fact that 6 people have died because of this school, I have not heard of a single judge, not one, in almost 40 years since this substituted judgment became a thing for these kids, where they've said no to aversives. And the idea that but parents should be the ones to make the major decisions when it's a child, or as they try to put it, incompetent. I got your incompetence. This lawyer's incompetent. Judges in particular are incompetent when it comes to making medical decisions for anyone. They went to law school, not medical school. I think you're pretty incompetent if you think that aversives is the only way. Okay? That's incompetent. It's this idea, well, if we take away it from the decisions and give it to the courts, and that's the question, if that's your question in all of this, and it's not actually that these kids are being tortured and no one's allowed to do anything about it, you should probably be going back to school. And stay there until you figure out that torturing disabled people is not going to cure us of our disability. It's not how any of this works. If a parent wants to put their kid in a treatment program that can be demonstrably shown to have caused bruising, scabs, post-traumatic stress disorder, where it can show that they were starved and sleep deprived, or in the more recent past, this in the 90s, up to 3rd-degree burns on the body. And that's the treatment program that they select. If you are a state government that has any conscience whatsoever, that's when the state should step in, because no parent has the right to subject their child to torture because it's called treatment. Point blank, period. I do not understand why this is a debate. But when that said state does step in, but they have a record of always signing off on whatever the JRC tells it to, and cannot provide a single instance where any judge has ever denied the JRC the ability to be able to torture its students. Comes murky, doesn't it? We're going to close on that. We don't get very many views on this channel. The few that we do tend to get removed from time to time. So please don't forget to hit the like button, hit subscribe, and don't forget to hit the comments. I do appreciate your time. And as always, folks, we here at Spilling Tea do hope you have a good one. Bye-bye, everyone.